Section 11. And be it further enacted, that there shall be appointed an attorney for said territory, who shall continue in office for 4 years, unless sooner removed by the President, and who shall receive the same fees and salary as the attorney of the United States for the present territory of Oregon. There shall also be a marshal for the territory appointed, who shall hold his office for 4 years, unless sooner removed by the President, and who shall execute all processes issuing from the said courts, when exercising their jurisdiction as circuit and district courts of the United States. He shall perform the duties, be subject to the same regulation and penalties, and be entitled to the same fees as the marshal of the District Court of the United States for the present territory of Oregon, and shall, in addition, be paid $200 annually as a compensation for extra services. Section 12. And be it further enacted, that the Governor, Secretary, Chief Justice, and Associate Justices, Attorney, and Marshal shall be nominated, and, by and with the advice and consent of the Senate, appointed by the President of the United States. The Governor and Secretary, to be appointed as aforesaid, shall, before they act as such, respectively take an oath or affirmation before the district judge or some justice of the peace in the limits of said territory, duly authorized to administer oaths and affirmations by the laws now in force therein, or before the Chief Justice or some associate justice of the Supreme Court of the United States, to support the Constitution of the United States, and faithfully to discharge the duties of their respective offices, which said oaths, when so taken, shall be certified by the person by whom the same shall have been taken, and such certificates shall be received and recorded by the said Secretary among the executive proceedings, and the Chief Justice, and Associate Justices, and all other civil officers, in said territory, before they act as such, shall take a like oath or affirmation before the said Governor or Secretary, or some judge or justice of the peace of the territory, who may be duly commissioned and qualified, which said oath or affirmation shall be certified and transmitted, by the person taking the same, to the Secretary, to be by him recorded as aforesaid, and afterwards the like oath or affirmation shall be taken, certified, and recorded, in such manner and form as may be prescribed by law. The Governor shall receive an annual salary of $1,500 as Governor, and $1,000 as Superintendent of Indian Affairs. The Chief Justice and Associate Justices shall each receive an annual salary of $1,800. The Secretary shall receive an annual salary of $1,800. The said salary shall be paid quarter-yearly at the Treasury of the United States. The members of the Legislative Assembly shall be entitled to receive $3 each per day during their attendance at the sessions thereof, and $3 each for every 20 miles travel, in going to and returning from the said sessions, estimated according to the nearest usually traveled route. There shall be appropriated annually the sum of $1,000 to be expended by the Governor to defray the contingent expenses of the territory. There shall also be appropriated annually a sufficient sum to be expended by the Secretary of the Territory, and upon an estimate to be made by the Secretary of the Treasury of the United States, to defray the expenses of the Legislative Assembly, the printing of the laws, and other incidental expenses. And the Secretary of the Territory shall annually account to the Secretary of the Treasury of the United States for the manner in which the aforesaid sum shall have been expended. Section 13. And be it further enacted, that the Legislative Assembly of the Territory of New Mexico shall hold its first session at such time and place in said territory, as the Governor thereof shall appoint and direct, and at said first session, or as soon thereafter, as they shall deem expedient, the Governor and Legislative Assembly shall proceed to locate and establish the seat of government for said territory, at such place as they may deem eligible, which place, however, shall thereafter be subject to be changed by the said Governor and Legislative Assembly. Section 14. And be it further enacted, that a delegate to the House of Representatives of the United States to serve during each Congress of the United States may be elected by the voters qualified to elect members of the Legislative Assembly, who shall be entitled to the same rights and privileges as are exercised and enjoyed by the delegates from the several other territories of the United States to the said House of Representatives. The first election shall be held at such time and places, and be conducted in such manner as the Governor shall appoint and direct, and at all subsequent elections the times, places, and manner of holding the elections shall be prescribed by law. The person having the greatest number of votes shall be declared by the governor to be duly elected, and a certificate thereof shall be given accordingly, provided that such delegate shall receive no higher sum for mileage than is allowed by law to the delegate from Oregon. Section 15. And be it further enacted, that, when the lands in said territory shall be surveyed under the direction of the government of the United States, preparatory to bringing the same into market, sections numbered 16 and 36 in each township in said territory shall be, and the same are hereby, reserved for the purpose of being applied to schools in said territory, and in the states and territories hereafter to be erected out of the same. Section 16. And be it further enacted, that temporarily, and until otherwise provided by law, the governor of said territory may define the judicial districts of said territory, and assign the judges who may be appointed for said territory to the several districts, and also appoint the times and places for holding courts in the several counties or subdivisions in each of said judicial districts, by proclamation, to be issued by him, but the Legislative Assembly, at their first or any subsequent session, may organize, alter, or modify such judicial districts, and assign the judges, and alter the times and places of holding the courts, as to them shall seem proper and convenient. Section 17. And be it further enacted, that the Constitution, and all laws of the United States which are not locally inapplicable, shall have the same force and effect within the said territory of New Mexico as elsewhere within the United States. Section 18. And be it further enacted, that the provisions of this act be, and they are hereby, suspended until the boundary between the United States and the state of Texas shall be adjusted, and when such adjustment shall have been effected, the President of the United States shall issue his proclamation, declaring this act to be in full force and operation, and shall proceed to appoint the officers herein provided to be appointed in and for said territory. Section 19. And be it further enacted, that no citizen of the United States shall be deprived of his life, liberty, or property, in said territory, except by the judgment of his peers, and the laws of the land. Approved, September 9, 1850. An act for the admission of the state of California into the Union. Whereas the people of California have presented a constitution and asked admission into the Union, which constitution was submitted to Congress by the President of the United States by message dated February 13, 1850, and which, on no examination, is found to be Republican in its form of government, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that the state of California shall be one, and is hereby declared to be one, of the United States of America, and admitted into the Union, on an equal footing with the original states, in all respects whatever. Section 2. And be it further enacted, that, until the representatives in Congress shall be apportioned according to an actual enumeration of the inhabitants of the United States, the state of California shall be entitled to 2 representatives in Congress. Section 3. And be it further enacted, that the said state of California is admitted into the Union, upon the express condition that the people of said state, through their legislature, or otherwise, shall never interfere with the primary disposal of the public lands within its limits, and shall pass no law, and do no act, whereby the title of the United States to, and right to dispose of, the same shall be impaired or questioned. And that they shall never lay any tax or assessment of any description whatsoever upon the public domain of the United States, and in no case shall non-resident proprietors, who are citizens of the United States, be taxed higher than residents, and that all the navigable waters within the said state shall be common highways, and forever free, as well to the inhabitants of said state, as to the citizens of the United States, without any tax, impost, or duty therefor, provided that nothing herein contained shall be construed as recognizing or rejecting the propositions tendered by the people of California as articles of compact in the ordinance adopted by the convention which formed the Constitution of that state,